Good afternoon. Thank you for coming. I'm Attorney Brian Mahoney, and welcome to the top 10 estate planning mistakes and how to avoid them. We have a PowerPoint on the TV. A couple of just real brief ground rules. If you could shut off your cell phone ringers. And the hard part of that is remembering to turn them back on when you get out. I go to meetings or court a lot, and I get calls from people, and I forget to turn my phone back on. And we gave you some paper and pen. If you could please write down any questions you have, I'll be happy to answer them at the end of the presentation. So, I'm a local guy. I was raised in Norfolk County, graduated Canton High School in 1974, graduated with honors from Northeastern University in Boston in 1979, and I'm a graduate of Suffolk University Law School in 1982. Graduated there cum laude, and I've been an attorney for 35 years, and I specialize in estate planning, asset protection, and elder law. And so bad things happen to good people. They always happen unexpectedly, so we plan. We live for the best, hope for the best, and plan. I say my job is to help you to protect those you love and to safeguard your home and hard-earned assets. Now, estate planning mistake number 10 is not avoiding probate court, and this is in two parts. Part A is you want to avoid what we call living probate. Living probate can happen if you become disabled and you don't have the proper legal documentation. So you want to make sure that you plan while you can. None of us are bulletproof, so we want to make sure we avoid living probate. That's probate while we're alive, because it costs a lot of money. On average, I'd say lawyers in Norfolk County probably cost around $3,000 to $5,000 to obtain a guardianship or a conservator. That's for yourself. And probate court is very difficult. The probate court employees work really, really hard, but there's not enough of them, and they have too many cases. Probate courts in Massachusetts handle divorces. The United States has the highest divorce rate in the world, and they have 1 million cases at probate court. The probate court handles estates. When someone passes away, you have to process your will. They handle interpretation of trusts. They handle guardianships, conservatorships, restraining orders, injunctions. They have so many different types of cases, and they're very, very understaffed. And that partially contributes to the waiting time. Average probate case will be at least 2 years. Average legal fees will be anywhere from $6,000 to $8,000 up to $22,000. And so you want to avoid probate for your family during life and after. So how do we avoid living probate? First document is a healthcare proxy with advanced medical directives and a HIPAA medical release within. So your healthcare proxy document allows you to name someone that can help you out with healthcare decisions. And if you can't make a decision yourself, trauma, senility, dementia, whatever it might be, then that person will make the decision for you. I draft my documents so that the minute it is signed and executed and notarized, your healthcare agent, the person you appoint, can access all of your medical records, can get consults from your doctors. And the reason I do that is because if you need help, but you can still make your own mind up, you might be ill, you might be too injured to go out. We had a skier once, he broke his leg, snow and ice out, and he said, "Brian, can we send my wife to get my records with this healthcare proxy?" And I said, "Sure you can." So it can be an inconvenient situation or a situation where someone just needs help. And this document allows them to get the help. And you need knowledge in order to make a knowledgeable medical decision. And this document allows your appointee to get that decision, get the information so they can make a good decision for you. That's a healthcare proxy with advanced medical directives and HIPAA release within. If you had no such document and someone had to make a medical decision for you, they couldn't do it, your family would have to go into probate court and have a guardian appointed. And you don't want to do that under a time of stress. Nothing gets done on time. The courts are clogged up. And so it would be a nightmare and it would cost a fortune. So that can be avoided. It should be avoided by having a comprehensive healthcare proxy with advanced medical directives within it. Advanced medical directives mean you can tell your healthcare agent, if this happened, I don't want to have this. Some people don't believe in blood transfusions. Some folks today, and a lot of folks today say, Brian, if they can't make me any better, if I can't think, please let me go. Don't do any more surgery. Don't do any more x-rays. So whatever your choice is, we try to personalize it for you if you have any directions like that. The other important document is a durable power of attorney. A durable power of attorney is like a healthcare proxy for your assets. So I start with the healthcare proxy first because that's your most important asset is your health. And then if you needed help making decisions with your finances, or if you need someone to go to the bank, whatever it might be for financial assets mostly, the power of attorney is the person that would control your assets. That's a very important document to have as well. If you don't have that and you need to do something with your assets, or if someone was disabled at any age and they needed to go into a nursing facility, you couldn't apply for Medicaid, you couldn't sign them in without the power of attorney. So it can be crucial, and certainly it can be used also in times of, for convenience. You could be on vacation visiting the children in Florida, need something done at home, your healthcare proxy could do that. But without that document, the family has to go into probate court and have a conservator appointed. And again, you're looking at months worth of time to get that done and thousands of dollars, and those are wasted. So you can avoid living probate by those two important documents. And then mistake number 10, part 2, is not avoiding probate after you pass away. A will is a document everyone needs. It's very important. But a will is not the most desirable way to have assets pass to your surviving spouse or to the next generation. Property passes to your spouse or the next generation in a number of ways. One is if it's a joint ownership, a joint tenancy, you own property together, you have your names on the bank account. The second method is through a beneficiary clause. Life insurance, retirement funds, things like that have beneficiary clauses. The third way property can pass to a surviving spouse or to the next generation is if it's owned by a trust. If it's not jointly owned, if there's no beneficiary clause, if it's not owned by a trust, then it has to be retitled into the names of your heirs through probate court. You want to avoid probate court because it's expensive. I've gone through the time delays, the reasons why, and the costs. But you can't avoid that for your family. And it makes it easier for your family when things go that easy. I had a client recently, and it's odd the way things happen in life. We were just talking about him because he was a skier. I'm a snow skier too. Next year will be my 50th season skiing. And this gentleman, we were wondering about him, and unfortunately, the next call we got about him was from his widow, and he had passed away suddenly and without warning of a heart attack. And so she came in with her sons, and there was very little she had to do because we had everything tied up. All his beneficiary clauses had been done. We had trusts for them. So they didn't have to go into probate, and it made it very, very easy for her in a time, that was really, really hard. So I just talked about a trust. So trusts are widely used, commonly used, and they're very effective in avoiding what we call death probate. It avoids delays, it avoids legal fees, and it avoids a lot of headaches for the family. So we call them living trusts. So as you can see, you can put whatever you want into your trust. It could be money, could be stocks, could be your home. You can be the trustees while you're alive, and then you can be the beneficiaries while you're alive. So you control everything while you're alive. Your spouse can be your successor trustee, and then when both spouses are gone, or if you're not married, or if you're a widow, when you're gone, it goes to your beneficiaries, your children, your grandchildren, whoever your loved ones and heirs are. It passes to them outside of probate. That's the important thing. And in the trust, you can name who the boss of the trust is. You can be in control while you're alive. It's a private document. It doesn't have to be recorded. And it's a standby vehicle. It doesn't have to go get gas at the probate court when you're gone. It's all set up and ready to go for you. All trusts aren't the same, though. There are many different kinds of trusts. And so if you've had a trust drafted before and you haven't looked at it in a long time, and to me a long time would be more than 5 years. Anything over 10 years is probably a pending disaster. So you have to look at them, and sometimes certain clients don't know what they have. Folks call me up all the time and say, Brian, can you review this document for me? A lawyer did it for me 10 years ago, 12 years ago, can you look at it? And a lot of times people confuse an irrevocable trust with a revocable trust. Sometimes they think they have a tax trust and they don't. So it's good to know what you have, and it's good to know what you need. Does what you have make sense for you now? I'd be happy to answer your questions at the end. If you want to write it down, that would be great. Yeah, thanks. And I'll answer everyone's questions at the end. We'll have, and if I can't get to you at the end, or if you have to leave, there's one couple here who has to pick up their grandson, you can call my office and I'll be happy to answer your question on the phone or make an appointment so we can talk. So all trusts aren't the same. It's kind of like cars. They're all different. They all cost different amounts, and some are better quality than others. Some have better brakes. Some have stronger doors in case you're hit. So all trusts are not the same either. And so you want to know what you have while you're still able to get it reviewed. The only time you can't do anything about it is if you're gone or if something happened. It's not just Alzheimer's or dementia. I had a 45-year-old client that was in a motor vehicle accident. He got hit in the head and he was permanently, totally disabled from there on after for the rest of his life, and lived in a group home. Young, strong guy, was a baseball player, part-time, and he never got a chance to do anything for his family, so we had to go into court for a conservatorship and a guardianship at a time when the family needed money because the breadwinner was taken out of the game, unfortunately. So was the trust written correctly when it was done? Some weren't, some aren't. I have a client, lovely woman from Weymouth, had what she thought was an ILIT, an irrevocable life insurance trust. That's designed to take the life insurance out of her estate so it's not taxed in Massachusetts. And we'll talk about the Massachusetts estate tax in a little bit. I read the trust and it didn't do that. So she had a bit of a problem with that. So we had to try to fix it. So sometimes they weren't written correctly when they were done. Sometimes they get outdated. Relationships change. Trustees could pass away that you've named. They could be disabled. Maybe they don't want to do it anymore. Maybe they've moved to California. You never know. The laws change all the time. We have tax changes. Recently, big, huge tax law, which I'm sure everybody in here knows about. They also changed the estate tax rules to a certain extent. So things change all the time. And so an estate plan isn't something you do once when you're 40 years old and you have little children. You really need to look at it every few years because things change. And you'd be surprised at how much better things are when you review it with a professional. And by the way, most lawyers will look at your documents without a fee. So if someone calls me up, I will look at their documents and review them at no charge. So don't feel like you're going to have to pay a lot of money. You probably won't have to pay anything, and they'll look at them. Did you have alternates? So every estate plan should have a backup, an alternate. I don't know if there's any Patriots fans, but a couple of years ago, Tom Brady was suspended. Then they had Jimmy Garoppolo, and then he got hurt, and they had a third quarterback, Jacoby Brissett. So if they didn't have alternates and backups, they were in deep trouble. Did you get all of your assets into your trust? Sometimes folks have a really nice trust drawn up, but nothing is placed into it, or they didn't have their beneficiary clauses worded so that when they passed away, their assets would go into the trust. We call that funding. So you want to make sure that not only do you have the right trust, have you put the right assets into it. Then we have, will it protect your children and your grandchildren? So one of the most important topics that I deal with now is asset protection. It's not enough to have your property go to who you want it to go to. You also want some protection for them when they inherit. You want to make sure that what they are intended to receive from you will not be taken by an outsider, whether that be a creditor, a controlling or out of control, a controlling spouse, an unscrupulous business partner, whoever it might be. You want to make sure that when you leave your hard-earned post-income tax dollars to your loved ones, that you can help protect it. I call it keep it in the family. Keep it in the family and away from the bad guys. We're in a very litigious society. Anyone can be sued. So we want to make sure not only that it's left to them in the proper way, but that it's worded so that there is some protection for them. Very important. Mistake number 8 is failing to protect against disability and the dreaded nursing home issue. So a nursing home costs about $400 on average per day in Massachusetts. A house could be eaten up under those daily numbers in 3 to 4 years, easy. So it's very expensive. And sometimes clients come to me and ask me what type of trust or life estate deed can help them to protect their home. So we go through that. There's a lot of things you can do. You want to protect your home as you age, but you don't forget the 5-year look-back period. So you have to keep in mind that there's a 5-year look-back period. So if you did something that is appropriate for Medicaid nursing home planning, you have to do that appropriate planning 5 years before you are ever going to go into a nursing home. It's called the 5-year look-back period. And there's a couple of ways to do that. And one is an irrevocable income-only trust. So an irrevocable income-only trust means that you can't change the trust and you're entitled to income from it. So you could put your home into this type of trust, and after 5 years it could be protected against Medicaid. And you can get income from that trust. So most people don't have any income from their home, but sometimes folks sell their home and maybe downsize. So you can do that with this type of trust. And if you invest money, you can get the income. So the government allows you to place your property into a trust if it's irrevocable, meaning you can't change it. And all you're entitled to is the use of income. You can't use principal. So what that means is if you had your home in such a trust and your trust sold it, and let's say they realized $300,000 net, you can't take any of the $300,000, but you can take the $300,000 in the trust and earn income on it. So there's a couple of limitations on it in order to safeguard your home. There's another method which is called a life estate deed. A life estate deed is you take your deed to your house and you say, I am deeding myself a life estate deed and I leave the remainder interest to my children in trust. That's another method for avoiding Medicaid claiming your home as a countable asset. And both are subject to the 5-year look-back period. And if anyone wants a memo on that, I have a really nice, easy to understand in layman's terms, nursing home planning memo. It's about 4 pages long, and I've worked very hard on it. So I think it tells you everything, and it'll give you a good idea of the pros and cons of those. And so even if you don't make the 5-year look-back period, even if you don't do anything, if you had to go into a nursing home tomorrow, there's always something we can save. It may not be a fortune, but it's something. And whatever we can save goes to your family rather than to a nursing facility. And if I can do that for someone, I feel good that I've helped them out. So mistake number 7 is not protecting your beneficiaries for themselves. So what does that mean? Clients say, Brian, I have grade A beneficiaries. My son is a nuclear physicist that won the Nobel Peace Prize. My daughter is a saint. She's a poet. She won a Grammy Award. She's a millionaire. They don't need protection. They're brilliant. And they might be, but bad things can happen to anyone. And it can happen to brilliant, successful people of any age. So we want to protect our beneficiaries in our trusts. A few minutes ago, I spoke about asset protection. And part of asset protection is making sure that we can protect beneficiaries from themselves. And it's not always the beneficiary has a problem. And I'm not going to go through all the problems, but people have problems, and they're not always readily apparent. And if someone had a problem like drug addiction, alcoholism, gambling, losses at business, these are not things that folks share. Typically. And typically children aren't going to share those types of things with their parents. Even though there's really nothing to be embarrassed about, we're all human, none of us are perfect, people tend to keep that inside and keep it away from their parents. So recently I had a client who came back to me. He got divorced and he needed a new estate plan. And he has 3 children and a nephew who he was taking care of, plus a disabled sister. And I suggested to him that he have a trust and he put some asset protection in there for his children and for his nephew and for his sister. And he said, no, I don't need it. Everybody's doing fine. I said, okay. I said, do you mind if I revisit this issue in the letter I'm going to send you, telling you why you should do it? And he said, no, please do that. And I told him in the letter something about really kind of what I just told you guys, is that I said, Charlie, your family might not tell you they have a problem. You might not know they have a problem, ever. And so if they don't have this mechanism in place, if they're not protected and they have a problem, that means they need your money more than ever. So let's say someone has a problem of some sort. Remember the recession in 2018? That's only 10 years ago. I know half a dozen clients lost their jobs. People had all kinds of problems. And that's something that everybody knows about. But let's say one of them had another problem, a secret problem they didn't share. The parents were never going to know they had that problem. And if they never did the trust because they thought their son was doing great and something happened to them, then the son loses the money. And if someone's disabled or they're having a hard time, they're going to need their money more than ever. And think about it. I have folks all the time worth maybe $200,000, $300,000, $400,000. I have clients worth up to $10 million. But a lot of clients say, well, I only have $300,000. It's not much. But they have 3 children. Who couldn't use $100,000? That can make a huge difference in anyone's life. Now, let's say I had some clients in yesterday afternoon around 4:30. They have $4 million, and they only have 1 son. And so they're going for the asset protection. But think about it. Unfortunately, for a lot of people, the only time they're ever going to see a lot of money, or money in 6 figures, is when their parents are gone. It's kind of a lousy way to get it, but it's a lot of money. So you want to make sure that they're going to get it. You don't want it to go to an ex-spouse. You don't want it to go to creditors. You don't want it to go to anyone but your family. And so that's why we try to build some asset protection within the trust to protect your beneficiaries. Very, very important. That's basically keep it in the family. Bad things can happen to good people. And you never know what's going to happen with someone. So you also want to protect from others. There's a lot of sharks out there. There's a lot of con men. That's why it's a disaster to leave property through a will, especially if it's left to a grandchild, because there's people out there that search through records. They could find out when someone's going to inherit money, and they can find out that they're only going to be 18. And guess what? They could be taken advantage of. So if the trust is properly worded, it decreases the chance that someone's going to basically take their money. Let's say someone is sued. You can word a trust to put up speed bumps, roadblocks, iron curtains, if you will, to block creditors from collecting. My job as an estate planning lawyer is to try to keep the money in the family, keep the money in the trust, prevent it from going to outsiders. Because if someone has a problem, they need that money more than ever. And the divorce rate now is over 50%. Bad luck with bankruptcy, lawsuits, easy to get sued. And we'll get back to, at the end of my presentation, I have an important case to talk about involving a bankruptcy and retirement plan funds. So number 6 mistake is failing to protect your beneficiaries from others, potential problems. You don't want a will just leaving property to someone because it has to go through probate and it's 100% subject to creditors and it's on public record. You don't want to have a trust saying when I'm gone everything goes to my spouse, when she's gone everything goes to the children outright, because under those circumstances the creditors will get the money before your family member does. Let's go on to outright distributions. So anytime you leave property to someone outright, there's no protection. The creditors go into court, they get an injunction. So if you had a probate estate, the creditors sue the probate estate. They go in, ask the judge for an injunction preventing them, the estate, from paying your beneficiary until they prove that they have a valid lien. So they bring in a judgment. The judgment is good for 20 years in Massachusetts, and you can re-up it. So essentially, you could be hounded by a judgment for the rest of your life. 20 years, you can go in and get it continued. And judgments carry interest anywhere from 6 to 12%. So if someone sues you and they win $10,000, after 20 years, it's not worth $10,000 anymore. Worth closer to $20,000 to $30,000, depending on the rate of interest, 6 or 12%. So that's why we want to not have outright distributions, and we want to make sure that we have something set up that can protect them. So I liken this big burly guy here in the security outfit, the police outfit. He's your trustee. He's guarding the vault. And if you have it worded properly, then the only person that can access that vault is your trust beneficiaries. So you want to have them have access to the trust funds, but not creditors. And it offers flexibility, and it avoids probate as well. So problems with the kids. We have a hypothetical with 3 children. One is really smart. He's a doctor. He has trouble with his marriage. The daughter, very nice woman. We'll talk about her as well. Jane has no financial experience. She also has some issues in her marriage. And then the third son, Jim, has some substance abuse issues and a disability. So he has creditors chasing him. So there's a lot of problems here that an estate plan would have to cover. So let's take Bob Jr., the physician. We can set up a trust that includes Bob Jr., and what we do is we word the trust so his spouse can't get the assets. We word the trust so that if he got divorced, a probate court judge could not order the trustee to release the money to the ex-spouse. And you can have documents set up that would decrease the chance of a patient being able to sue Bob successfully and collect. So that's what we can do for Bob with trust documents and other asset protection mechanisms. And for Jane, we can set up a trust where a trustee watches Jane's money. Trustees can be hired. You can hire a professional. If you have someone that can't really do the work, is not knowledgeable, and I'm going to talk further on that too in my presentation, then you can hire an expert. You have to pay for the expert, but they know what they're doing. That's what they do. And it's better than leaving it to someone who might squander it. Or what happens a lot is a controlling, out-of-control spouse wants the money. We had a client, he's saying, you know, the husband kept hounding her for money. She had money that she had inherited. And every business that this man had failed, and he was hitting her up for another 300 grand, and she didn't want to do it. She didn't want to give it to him. And so what can happen when someone passes away, if they don't protect the money, you also leave them susceptible to that out-of-control, over-controlling spouse. Or it could be a business partner, too. I've seen that as well. So it's nice sometimes to have a professional trustee watching the money. For Jim, you can set up what they call an SNT, a special needs trust. A special needs trust is a really good idea for people who are disabled. People who are disabled struggle. They're on fixed incomes, can't work or can't work full-time, and they always need money, and it's really hard for them. So this type of trust is allowed by the government, And you can leave property to a disabled person in this type of trust and have the same protections that you can have for everyone else, and they can remain eligible for public assistance benefits. So if you have a grandson that's disabled and always will be, you can leave money to him in a supplemental needs trust. That grandson will always be able to collect SSI. They'll always be able to get mass health insurance and still have a trust fund. And if anyone has a disabled relative, I wrote an article about 9 years ago. It's still current on what a special needs trust can pay for. And that would give you an idea. They're very flexible. So that's very good. We could do that for Jim. So there's a lot you can do for every family. And basically, we talk about asset protection with everyone. Asset protection also involves, do you have an umbrella policy? Do you have more than the minimum requirement for auto insurance? I can't think of an easier way to get sued than the automobile. We're all busy. No matter what age we are, no matter what we're doing, everybody I know is busy. My retired friends are busy, retired clients are busy, my daughter's 20, she's busy all the time, I'm busy all the time. So it's easy to get distracted, it's easy to get tired, and it's easy to be in a car accident. So you want to make sure that you have enough auto insurance and that you have an umbrella policy on that as well. Very, very important. Mistake number 5 is thinking your living trust covers your retirement plan benefits. Retirement plan benefits do not typically go into an average trust. Retirement plan benefits are very complex. They have unique and labyrinth-like rules on income taxes, distributions, and typically an average trust that you may have had that was not designed specifically for retirement plan trusts would not work with your retirement plan benefits. I can tell you why you would want to potentially have a retirement plan trust for your retirement plan assets. And so in 2014, this is the bankruptcy case I was referring to earlier. In 2014, a parent had passed away and she had left, I think it was up to $1 million to her adult daughter, Heidi. Heidi and her husband had had severe business setbacks. They were over $1 million in debt. The mother intended her daughter to inherit $1 million from her through her IRA in a beneficiary clause. We've probably all seen the beneficiary designation forms. You get a form from your company, your bank, you fill it out, you say, if I die, primary beneficiary is my husband, contingent beneficiary is my 3 children in equal shares, and then you list them. So that's kind of what Heidi's mother did. Simple and cheap. But as we'll find out, simple and cheap doesn't always work, because when the mother passed away, the creditors of Heidi and her husband intervened. They went into court and they got an injunction. And they asked the judge to stop the IRA company from paying Heidi the money, because they said it belongs to us. Heidi's lawyers said, hold on a minute, this is privileged. An inheritance from a parent to a child is privileged and cannot be attached or taken by creditors. Heidi lost. So she lost $1 million plus whatever it costs to get up to the Supreme Court, which has to be 6 figures. So unfortunately, she lost $1 million and she lost legal fees as well. That didn't have to happen. There is a trust, I call it a retirement plan trust, that can inherit retirement plan benefits for your children, your grandchildren, your loved ones, whoever it might be that you care about and want to leave assets to. That trust can provide some asset protection for a family member should there be a problem when you're gone. Heidi's mother used the beneficiary designation form, but that won't work. If someone has a problem and you use the beneficiary designation form, they will lose money to creditors. If you leave it to a retirement plan trust, a specialized trust that deals only with retirement plan assets, then you have a chance to keep the money within the family and to avoid the creditors. Another aspect of retirement plan planning is this. You see that little cookie jar? Basically, I look at a retirement plan as being for a rainy day. To me, retirement benefits are used for when you can't work anymore and you have a limited amount of funds to live off, and that's when you start tapping into them. An unfortunate statistic that I've read is that 60% of people who inherit an IRA or a retirement plan benefit liquidate it immediately. Typically, with no plan, they take the money out. So if you inherit, say, $100,000 in an IRA benefit, and you cash it in immediately, you become the worst financial planner in the history of Earth with one fell swoop because there's an income taxable event. That will be reduced by 20 to 25%, give or take, for federal income taxes. So you take 100,000, let's say it's only 20, now it's 80%. And now they just start to spend, they have no plan. If you have a retirement plan trust, you can word it so they get a certain amount per year or a certain amount upon certain contingencies. So it's not an ATM. Because it's really nice if someone has a fund towards the end of their life. Now, a lot of people say, well, I want it when I'm young. And we all would like $1 million when we're 25 years old. But how many people, don't have to raise your hand, would think that $1 million would be left when they're 65 or 75, when you need it, because you can't work? And if you're thinking also protecting your house from Medicaid, think about yourself. Everybody is parents. I'm a parent too. We think about our children. If you're retired and you don't work anymore and you can't work anymore, be careful if you put property beyond your control because you might need it. Think of your children, but you can also think they can still work. They're young enough if they're not disabled. So be careful, what you do with your assets as well in that regard. So that's a retirement plan trust. And very, very, very popular now. I've been drafting them since about 2008, and they can really, really, really provide some great asset protection. Mistake number 4 is failing to consider Massachusetts estate taxes. So the new tax law just changed the federal exemption. So for the United States of America, you do not owe an estate tax unless your estate is worth more than $11 million. So that excludes, I think, something like 99%, maybe 98.5%. It excludes me. I assume it excludes everyone here. However, Massachusetts is only $1 million. So if you're under $1 million in Massachusetts when you die, you don't have to pay an estate tax. If you're $1 million and 1 penny, you have to pay an estate tax on the whole amount. So federally, if you're worth $12 million, you take off 11, you pay on $1 million. Massachusetts, though, if you're $1 million and 1 penny, you pay on the whole amount. And it can add up. And when I said, be careful what type of trust you have, know what kind of trust you have. Not all trusts are created equal. This is part of it, because a lot of people come to me sometimes and say, Brian, this is going to eliminate estate taxes. And then I read the trust document, and it's just a basic trust, without any estate tax avoidance. So I can give you, they call it a death tax. One of the problems with the death tax in Massachusetts is due in 9 months. So that can be a problem if you don't plan for it, because what if it's all in real estate? What if 2 homes have to be sold in order to pay the death tax in 9 months? What if it's a down real estate market? What if someone died in 2006? I don't know if anyone remembers 2006, but property values in Norfolk County went off a cliff. From record highs down probably 2006 to 2008, property values probably down at least 20%, I think, maybe 25. So if you have to sell under those conditions, the family would realize a big loss. So it's nice to figure out what you might owe on estate taxes, because you don't want to have a fire sale. We don't want any price. We want the loved ones to get the full value of their assets. So what can you do then? If a couple was worth $1.8 million in Massachusetts, the ultimate death tax in Massachusetts would be about $80,000. You can avoid paying that. You can eliminate from ever being estate taxed in Massachusetts if you have the right type of trust, you can eliminate up to $1 million in your trust when you die from ever being estate taxed. And I have an example I can show you. So assume these folks had $1.8 million, and assume, to make this easy, we could divide all the assets for the husband and all the assets equally for the wife. And men still die 5, 6, 7, 8 years earlier than their female spouses. So if we assume the husband passed away first and we had $900,000 in his estate tax avoidance trust system, that would never be estate taxed in Massachusetts. And if it grew to be, say, $1.3 million when the wife passed away, none of the $900,000 or its growth would be included in her gross taxable estate. So we're essentially shielding from being taxed the whole $1.8 million, because when the spouse passes away, she's only going to have $900,000, maybe less if she's been living off it. That's under $1 million. And so the family saves basically about $90,000. So if you're worth over $1 million, you want to look into that. That would be the net value of your home, your IRAs, your bank accounts, whatever you have for investments, the death benefit of life insurance, pretty much everything you own and whatever someone might be entitled to at the date of your death is included in your gross taxable estate. So that's estate taxes in Massachusetts, and a lot of people do not look into that, or they think they had, but they hadn't. That's why we like to review things. Mistake number 3 is believing your trustee might know what to do when you're gone. And this will dovetail into something that's becoming a very increasingly important topic in estate planning, and that's called family harmony. Who would you select as your trustee? Have you named a child as trustee? Are you thinking of naming a child as trustee? There's a law review article I was recently reading by an estate planning attorney with 30 years experience. He wrote it for the Marquette Law Review. In his opinion, he said any family that names a child or children as a trustee or representative of their estate has a 1 in 3 chance of having a fight break out. Family disharmony, litigation.
It's terrible.
It is terrible, and money-wise, it costs probably 10 to 15 times more when there's a problem than if you had an airtight estate plan to begin with. Litigation just costs a fortune. And most people that are named to act as trustees have never done it before. And you know, a lot of clients, they automatically name their children, and I understand why. They're your children. We all think our children are great, and some of them are. But how many are experienced? And the trustee can have liability as well. So you want to protect them against themselves. You don't want them liable for mistakes. You don't want to put anyone in over their head. And you want to eliminate family arguments or the potential for family arguments. And that's why sometimes I recommend a professional trustee. So I'll just back up one sec. I had a client came in one time. He had $3 million in assets, and he wanted to name his son. His son was going to be the trustee for himself and his 3 sisters. And I met the son, and I spoke with him, and he was completely unfit to be a trustee. Nice kid. But how do I tell that to the father, the dad? It's his son. It was a really bad idea. So I said, Mr. Smith, if you had a company worth $3 million, would you allow me to run it if I wasn't a lawyer, if I didn't used to be an accountant, if I never managed more than a couple of $1,000s, if I had no experience managing other people? Keep in mind, a trustee has to deal with beneficiaries, so you have to be able to deal with people, in that case, his siblings. I said, what if this person had no bookkeeping experience? And they had no experience running a company? Would you allow that person to run your $3 million company? He said, no. Why would you even ask me that? I said, isn't that what you're asking your son to do? And to his credit, he thought about it, and he said, wow, you're right. I never thought about it like that. So it worked out for me because I didn't insult him and his son, And it worked out for him because we picked someone that was suitable and he hired a professional. And it cost money, but he knew the job would get done. And he knew also that if the family members were mad about it, he was gone. They couldn't yell at him. And it's a professional trustee. They're used to getting yelled at. It's not an easy job being a trustee sometimes. And so that is very, very important. Picking the right trustee. We covered this a little bit earlier. Changes. We want to review our documents. It's not your one and done. It's not your set for life. You really need to look at them because things change. I have clients call me all the time. This happened, or my son passed away. Recently we had an older client call me, and she wants to reallocate the money to her 2 surviving daughters. So we have to change a few things for her. And her trust was 11, 12 years old, and her power of attorney was out of date. And so we can draft new documents for her and protect her. So whatever you do, it's important to get a checkup. It's, you know, every couple of years, make sure you check in, make sure it still works. Because everything changes. Estate planning techniques change, outlooks change, everything changes. And so you can't keep up with it on your own, so you need some help. And we'll get to the last mistake. This is the biggest mistake. Doing nothing. I'll get to it. You know, I'm too busy. We're all busy. I understand. I'll get to it. I don't know. Yeah, let's wait till the spring. I don't like going out in the cold. It's icy. And in the spring, I'm playing golf. We'll do it in the summer. In the summer, babysit my grandkids. We'll do it in the fall. In the fall, my wife and I decided to go down to, I don't know, Florida or something. Then the holidays come, and then it's Christmas or New Year's, and then you're back around. So it's easy to do. And so if you want something done, if you're here, get something done, get something reviewed, and I can give you some guidelines on who you'd hire, how you can do it, how I do things, and things like that. So let's go to, are you making these mistakes? You want to avoid them, where do you go? Well, you go to a lawyer. You go to an expert, someone that's been doing this type of work for a long, long time. So you don't go to rookies. Experience counts. You want to say, my attorney is an estate planning expert. They specialize in estate planning, elder law, asset protection, very, very important. You don't want to have someone that does drunk driving, immigration, personal injury, real estate. You want someone that does what you need, that specialty. My attorney's not a general practitioner. My attorney's, say, a member of NALA, for instance. So NALA is the National Academy of Elder Law Attorneys. That's one of the premier organizations in the country, I think. It's an association of over 4,500 attorneys whose mission it is to advance the rights of the elderly and the disabled of any age. You want to say your attorney's written articles, lectured on topics. You want to say, I'm going to an expert. I feel good about that. So I can tell you a little bit about what I do. I've been an attorney for 35 years, since 1982. I drafted my first will working for attorney George Serratos in Stoughton while I was in law school, 1980. George did some estate planning, and that's where I got started. I'm a member of the National Academy of Elder Law Attorneys. I've been on their NALA News editorial board. That's a monthly journal we publish, and we write articles. I've written articles for the NALA Journal, the NALA News rather, on what happens if there's a problem at the nursing home. What are the parents and the family's rights? How should they approach it? I've written an article on special needs trusts. And so I've written articles for the Wealth Council. It's an association of about 1,100 estate planning attorneys nationwide. I've written articles for them on irrevocable Medicaid trusts. And I have an article coming out for the NALA Journal on representing learning disabled children. I'm not an attorney that represents learning disabilities, but my daughter has a learning disability, and I trust myself more than any other person in the world to take care of her. And so I learned how to do it. And I volunteered to write this article because it comes up a lot. Learning disabilities are through the roof over the years, and a lot of lawyers are going to have someone come in their office at some point saying, I need help at school to help my child. Very, very hard. And so NAILA is not just elders, it's also the disabled of any age. So we deal with children on up. It's the full gamut. I conduct seminars like this often. I do one annually at MIT. And it's fun. It gets me out of the office. I like to talk. I love this subject, and I can help people out. This is what I do: wills, trusts, powers of attorney, healthcare proxies, estate tax avoidance, elder law, Medicaid planning, and probate. So this is how I work. What I do when someone calls my office is I speak with them and get some information. And then I send them some memos. I like to write as well as speak, and I have a ton of memos. And I try to write them so they're easily understandable. I send out the memos to clients, and I send out a sheet, I call it a master list, that gets them planning their... Oh, we forgot to plug the laptop in. That's okay, we can get rid of that, thank you. So I send out the documents, and folks can learn from it, and then they can call me at any time. And I give them a sheet, really, the master list, where they can start saying, who's going to be my power of attorney? Who's going to be my backup healthcare proxy? What are my children's names? Who do I want things to go to? And then when I get that information back, I send out recommendations. And then we meet for a no-charge consult, and we go over my recommendations. And what's really nice about it is I know something about them, they know something about what I recommend, and it's really nice because we can make the best use of our valuable time together and get down to working out a plan. And thank you for coming. I really appreciate it. I had fun doing this. Good luck. Have a nice day. Bye.